Hello friends, I'm Sanjay. This is part 6 of the series where I'm covering the interpretation of statutes as per the standard LLB syllabus. The complete playlist for this series is available on the Lawment YouTube channel. In the previous parts of this series, I have covered the basics of statutes, the various types of statutes, and situations when interpretation of statutes may be required. We also saw all the internal and external aids to interpretation. We have also discussed the various presumptions in statutory interpretation. And in this part, we will cover all the important primary and secondary rules or principles of interpretation. To recap what we have previously discussed about the interpretation of statutes, if a statute is clear and unambiguous, it should be enforced or applied as is. If a statute is not clear or it has some ambiguity, that is where the need for construction or interpretation comes in. First of all, the primary rules for interpretation should be applied. If required, the secondary rules or principles of interpretation should be applied to fine-tune the interpretation that has been done by applying the primary rules. And the most appropriate interpretation of the statute should be implemented or enforced on the intended subjects of the statute. Also, the presumptions of statutory interpretation should be applied in each step of the interpretation process, and any interpretation that goes against the presumptions should be discarded. For example, the presumption of constitutionality, which is the presumption that the legislature cannot make any laws to intentionally violate the constitution. So, any interpretation which seems to violate the constitution will be a wrong interpretation and must be discarded. We will be discussing 16 different rules or principles of interpretation of statutes, which are the primary and the secondary rules. But how are they classified? What is the rationale? In the true sense, these are not primary and secondary in a hierarchy. The basic idea here is that the primary rules are applied first for general interpretation of statutes, and if required, the secondary rules or principles are applied in specific contexts. For example, the literal rule or the golden rule are applied first, and if the statute is a taxation or a penal statute, you may also apply the rule of strict construction. And if the statute is a welfare, environmental, or a consumer protection statute, you may apply the rule of beneficial construction. In most books, the first four, that is, the literal rule, the golden rule, mischief rule, and harmonious construction, are considered primary, and the others are considered secondary. In other books, even purposive approach and reasonable construction are considered to be primary and the rest as secondary. So check your specific university syllabus and you can see whether purposive approach and reasonable construction are classified as primary or secondary as per your syllabus. When we go into the details of all these rules or principles, you will see that there are overlaps and similarities between some of them. This is quite natural, and as long as the rules do not contradict each other on the same subject and in the same context, any overlaps or similarities are fine. The literal rule means that the judges should interpret the law literally, based on the text or the words of the law, using the ordinary and plain meanings of the words. Over the years, the courts have set out some basic principles on how to use the literal rule. Every word in the statute should be given meaning, as no word is unnecessarily used, which means that the law should be read in its entirety. Selectively reading some parts and ignoring the other parts is not literal interpretation. One should not presume any omissions, and nothing should be added by the court, which means that the court should not assume that the legislators missed out something and try to supply that missing part. Whether something seems extra or something seems to be missing, the interpretation should be literal. Normally, all words and terms are interpreted as per their ordinary meanings. If any term used in the statute is supposed to have a special meaning, then the statute itself should specify the same. This is usually done in the definition section. Technical words are given ordinary technical meanings if the statute has not specified any other. It should not be assumed that the statute is implying something, leading to the judge introducing something extra into the statute. What is written should be interpreted as is. Words undergo shifts in meaning in the course of time, so the interpretation should be done on the basis of when the statute was written. For example, before the Industrial Revolution, the word manufacture meant made by hand, and it evolved from the Latin term manufactus. And now manufacture means mass production, usually in a factory. So while interpreting a statute which has this word manufacture, the date when the statute was written should be taken into consideration. And words acquire significance from their context. For example, if a statute is related to fashion or apparel, then the word clutch may refer to a woman's purse, whereas in a law related to automobiles, clutch will refer to a transmission component of a vehicle. And a consideration before applying the literal rule is that it should not be applied if it is leading to an absurd result or it is defeating the purpose of the statute. And if one of the parties is claiming that the words used in the statute actually mean something other than their normal meaning, then that party has to prove the same. First of all, the judge should try to interpret a statute literally, that is, based on the normal meanings of the words used. If such a literal interpretation is leading to an absurdity or a contradiction, then the golden rule must be used. The golden rule is where the judge will modify the meaning of the words in the statute to make the statute more practical and enforceable. For example, if there is a law which says that vehicles are not allowed inside a park, the word vehicle can refer to any device that is used for carrying or conveying persons or objects. So technically, not only cars or motor vehicles, but even bicycles, prams and roller skates are called vehicles. Since the literal interpretation will lead to an absurd outcome, the judge can use a golden rule to interpret the term vehicles. And the judge can decide that the word vehicle as used in this statute means motor vehicles, and therefore allow bicycles, prams and roller skates to be used inside the park. Now the golden rule has two approaches, a narrow approach and a wider approach. If the literal interpretation of the statute is too wide, like in this example where the literal interpretation of the word vehicle is becoming too wide to include things that were probably not intended by the legislature, then the judge can take a narrow approach and reduce the scope of the words used in the statute. Or if the literal interpretation is leading to an absurd outcome, then the court can take a wider interpretation to make the law more meaningful by increasing the scope of the words. The advantages of the golden rule are that it allows for flexibility, it allows for reasonable decisions, and it can avoid unintended outcomes. At the same time, a possible disadvantage is that the outcome of an interpretation is significantly influenced by the judge, because a lot of this interpretation process is left to the discretion of the judges. Also, there are no specific tests on when the golden rule can be applied and when it should not be applied. And sometimes the interpretation that is done using the golden rule may actually turn out to be different from what the legislature actually intended with the statute. The Mischief rule or Heydons rule was first laid out in Heydons' case in 1584. So this is actually a very old rule of interpretation. A mischief means a wrong or a hardship that a statute is designed to remove or provide a remedy for. In simple words, laws are usually created to address an issue or to solve a problem of some sort. So the legislature is actually trying to address some issue through a statute. When a judge is constructing or interpreting a statute, he should first try to understand the true intent with which the law was created. That is, what was the mischief that was sought to be addressed, and interpret the law to make it effective. For example, if the speed limit in a school zone is 15 km per hour, then the mischief that is being addressed is that vehicles moving too fast can cause danger to the children in the school zone. So a judge can interpret the law to include even bicycles under the speed limit, because a person riding a bicycle at around 25 km per hour can crash into a school student and cause serious injury. So the judge is interpreting the law to ensure that the true intent of the law is met. Now the steps for using the mischief rule were laid down in Heydons' case, which are: first, the judge needs to understand what was the law before the specific statute was enacted. Second, what was the mischief or the problem that was sought to be addressed through the specific statute. Third, what are the details of the statute that has been enacted. And fourth, what is the true reason for the remedy, that is, the statute. Once the judge has the answer for all these four questions, he can then interpret the law to suppress the mischief, that is, to address the problem, and to advance the remedy. If there is an inconsistency or a conflict between two or more provisions of the same statute, or between the provisions of two different statutes, then the presumption is that the legislature would not have intentionally created such conflicting statutes. This is because it is also presumed that the legislature knows the state of the existing laws before it creates any new laws. Harmonious interpretation means that the courts should read such conflicting provisions in such a way that all of them are given effect and one statute does not end up overriding or negating the other. For example, you may have seen this sign outside banks stating that no firearms or weapons are allowed to be carried into the premises. Now, Article 25 of the Constitution guarantees the right to freedom of religion, and it says that carrying a kirpan is a part of the profession of the Sikh religion. So, when it is interpreted literally, the first rule, banning all weapons, is in direct conflict with the freedom of profession of the Sikh religion. Here, the court will interpret both the statutes harmoniously, such that this rule will apply on all persons except Sikhs who are carrying a ceremonial kirpan. In the Commissioner of Income Tax versus Hindustan Bulk Carriers case, the court also laid down the guidelines for using the rule of harmonious construction. First, the court must ascertain the intent of the legislature and give effect to it. The provisions should be read and interpreted in such a way that it reconciles them instead of making them contradictory. Similar to the first guideline, the court should adopt a construction that best serves the object of the statute. If one interpretation leads to an absurd result, while another interpretation gives better effect to the purpose of the statute, then the latter should be adopted, even if the former is grammatically better. If, despite harmonious construction, contradictions remain between the general and specific provisions, then the specific provisions should prevail over the general ones. The purposive approach to interpretation is quite easy to understand. The focus here is on the purpose of the statute. You will notice that there is a similarity with the mischief rule, where the focus was on the mischief that was intended to be addressed by the statute. In the purposive approach, the focus is on the purpose of the legislation, rather than just the literal meaning of the words. For example, the purpose of a law or a rule creating a pedestrian zone is to protect pedestrians. But interpreting the rule literally and saying that vehicles are never allowed to enter a pedestrian zone would cause undue hardship to any businesses who may have to transport their goods into their shops, which may be in the pedestrian zone. Using the purposive approach, the court can interpret this rule in such a way that the purpose of the rule, that is, to protect pedestrians, is achieved, and at the same time, injustice is not caused to any businesses in the pedestrian zone. The court can interpret the rule such that vehicles which have a specific reason to be in that zone are allowed, but only during such times when the number of pedestrians is very low, such as late in the night or early in the morning. If we compare the purposive approach with the golden rule, the focus here is to achieve the purpose of the law without modifying the words, whereas in the golden rule, the literal meaning of the words is altered to avoid absurdity or contradiction. The purposive approach is important because it is more flexible and more commonly used, whereas the golden rule is less flexible and not used so frequently. The rule of a reasonable construction can be explained and summarized in these 3 points. This is a principle where the courts aim to interpret laws in a way that is sensible and practical. It means interpreting laws in a way that makes sense in real-life situations and aligns with common sense. This approach helps to bridge the gap between strict legal language and the realities of everyday life. For example, suppose there is a statute which says that carrying any weapons, including sticks, is prohibited inside the building. Now, this man is carrying a stick that can be considered a weapon, and this should not be allowed inside the building, especially since there is no important reason for him to be carrying the stick. And at the same time, common sense tells us that this stick, the walking stick that is being carried by this old man, is less likely to be used as a weapon, and it is required for him to walk. So, rather than interpreting the law literally and banning all sticks, a reasonable construction allows the judge to interpret the law in such a way that it aligns with common sense, and the judge can decide what are the exceptions to the statute. Some of the advantages with this approach is that it is practical and flexible, whereas the disadvantage is that there is subjectivity, since it depends on the judge's interpretation of what is reasonable. Ejusdem generis is a Latin term that translates to of the same kind or nature. Ejusdem generis is a rule which says that if there are general words following particular and specific words, then the meaning of the general words must be confined to those things which are of the same kind as those specified, unless there is a clear indication of a different intention. For example, if the law says that the storage and sale of rockets, flower pots, sparklers and other articles is hereby banned, then the interpretation of these general words, other articles, must be confined to the same kind as the specific words. Since the specific words, rockets, flower pots and sparklers, are fireworks, then the interpretation of these other articles should also be other fireworks. Then this rule is essentially saying that the storage and sale of rockets, flower pots, sparklers and other fireworks is hereby banned. If the Ejusdem generis rule is not used, then this term other articles can mean any other articles. It may be clothes or decorations or puja articles, which are not fireworks. So this rule will essentially prevent the person from storing and selling anything and everything, which would be an injustice. On the other hand, if the intention of the statute was to ban the storage and sale of everything, then that should have been clearly clarified in the statute itself. To apply the rule of Ejusdem generis, the following conditions must exist. The statute must have some specific words like rocket, flower pot. The members of the enumeration, that is, the specific words, constitute a class, like fireworks. The class is not exhausted by the enumeration, that is, there should be other items in that class, apart from what are listed in the statute, like there are several other types of fireworks, other than rockets, flower pots and sparklers. A general term must follow the enumeration or the list of specific words, like here, other articles is a general term that follows the specific words. There is a distinct genus which comprises more than one species. In simple words, all of the fireworks can be put into a single class or a genus. There is no clearly manifested intent that the general term be given a broader meaning that the doctrine requires, which means that the statute does not clearly indicate that the scope of these words, other articles, is to cover articles other than fireworks. If all of these conditions are met, then the rule of Ejusdem generis can be used. Noscitur e Sociis is a Latin phrase that means it is known by its associates. This rule says that while interpreting a statute, the meaning of a word in that statute should be known from its accompanying or associating words. For example, if the law says that throwing trash into lakes, rivers, streams and other bodies of water is a crime, and there is a need to precisely decide the meaning of this other bodies of water, that is where the Noscitur e Sociis rule can be used. Since lakes, rivers and streams are natural bodies of water, this law can be said to include the sea as well. So throwing trash into the sea is also a punishable crime. However, a swimming pool, although it is a body of water, it is not a natural body of water. So swimming pools are not covered under this law. Another principle to remember in the context of this rule and other rules is that the same words will bear the same meaning in the same statute. Once you have decided as to what is the meaning of these words, other bodies of water, that meaning will apply wherever these words have been used in the same statute. you cannot keep changing the meaning of the words from one part of the statute to another. Unless, of course, there is a context as to why the meaning should be different in different parts of the same statute. Or there is a proper reason for changing the meaning. Or if using the same meaning in different parts of the same statute is causing some absurdity or injustice. Or if there is a different circumstance that is being dealt with in a different part of the statute. Or if the same words have been used in different contexts in different parts of the statute. You may also notice that this rule, Noscitur Sociis, is similar to the rule of Ejusdem Generis. Well, there is a difference. The Ejusdem Generis rule is applicable in situations where the words used in the statute are more general. Like if this law said that throwing trash into lakes, rivers, streams and other places is a crime. The words other places is very generic and the Ejusdem Generis rule can be used. But here the words that are used are more specific, that is other bodies of water. So the Noscitur Sociis rule can be used here. Expressio Unius est Exclusio Alterius. This is a Latin maxim that translates to the express mention of one thing implies the exclusion of another. The two conditions which need to be fulfilled cumulatively in order to apply this maxim are as follows. Firstly, the list of words appearing in a statute should be specific in nature. And secondly, those specific words should not be followed by general words. Then the act or the legislation will only apply to the specific words appearing in the list. For example, if there is a board which says car and bike parking 8 am to 10 pm. Here both the conditions are fulfilled. The statute has a list of specific words, that is car and bike. These specific words are not followed by any generic words. So the rule in this case clearly applies on the list of specific words, which means that only cars and bikes can be parked here, that too between 8 am to 10 pm. In the second board, it says car, bike and vehicle parking. So the first condition is met. There are specific words, car and bike. But the second condition is not met, since there is a generic word vehicle after the specific words, which means that cars, bikes and any other vehicles can be parked here from 8 am to 10 pm. To recap, the rule says that the express mention of one thing implies the exclusion of another. So if a statute mentions a list of specific words and there are no generic words that follows them, then the statute will cover only the specifically mentioned words and exclude everything else. The advantage with this interpretation is that the statute will clearly focus on what is expressly mentioned in it. The disadvantage is that it may lead to a very narrow interpretation, which may not be ideal, because the real intent behind the law may not be met. Reddendo singula singulis is a Latin maxim that means let each be put in its own place. This rule says that when a sentence in a law has several parts, then each part should be interpreted in connection with the words that are closely related to it. For example, if the rule says that interfering with the work of firemen, policemen and doctors in a hospital is prohibited, there are several parts in this sentence and each part should be interpreted in connection with the words that is closely related to it. In a hospital is closely related with the doctors. So this should be understood as interfering with the work of firemen, or interfering with the work of policemen, or interfering with the work of doctors in a hospital is prohibited. If the Reddendo singula singulis rule is not followed, then the sentence can be interpreted as interfering with the work of firemen, policemen or doctors in a hospital is prohibited, which means that interfering with the work of firemen or policemen or doctors outside a hospital is not prohibited. This does not make sense, does it? The advantages of this rule are that there is precision in interpretation and it avoids generalization. And the disadvantages are that this may make the process of interpretation more complex and there is an over-reliance on the text of the law rather than the intent. So imperfectly written laws may be interpreted imperfectly. Ut res magis valeat quam Pereat. This is a Latin term which means it is better for a thing to have effect than to be void. This rule is quite simple. It just says that when interpreting an unclear statute, the interpretation that gives effect to the statute should be preferred over one that invalidates the statute or makes it meaningless. For example, if there is a board which shows the pictures of a bike and a car and mentions that they are banned in a school zone between 8 am to 4 pm, does it mean that only cars and bikes are not allowed, but buses, trucks, autos, tractors and other vehicles are allowed? Since the real objective of the signboard is to ensure the safety of the children who may be walking in and out of school, it doesn't make sense to interpret this board to say that only cars and bikes are banned, because even fast-moving trucks, buses and autos may cause accidents. So the interpretation that best suits the intent of the rule is that all traffic is banned in the school zone from 8 am to 4 pm. And the board is only showing the pictures of a car and bike as examples, because putting icons of all vehicles is not practical. The advantage of this rule is that it makes laws more effective. At the same time, a disadvantage would be that the interpretation depends a lot on the discretion of the judge, making it very subjective. And there is also a possibility of the law being extended much beyond its intended scope. For example, what if the actual intention of this restriction was only to ban cars and bikes, and it is the interpretation that is extending it to all vehicles? Dissimilum dissimilis est ratio. This is a Latin term that translates to dissimilar things are governed by dissimilar reasons. In other words, if two situations or things are fundamentally different, then they should be treated differently under the law. For example, a labor law will not be applicable in the same way on all employees. There will be a differentiation between full-time employees, part-time employees, contract employees, and freelancers. This is because the working conditions and the terms of the contract with the employer will be different. So it is logical that the law should treat each category of employees differently. So the interpretation of a law should also be different in the context of these different types of employees. In some example landmark cases, the courts have used this rule to differentiate between ordinary cement and special cements, between newsprint paper and writing paper, and between primary and secondary markets for tobacco. The advantages with this rule are fairness, because the law is taking into consideration different situations or circumstances, and also flexibility. The disadvantages are subjectivity, because it is left to the discretion of the judge as to what is similar and what are dissimilar. This can lead to inconsistency in the application of the law. Casus omissus is a Latin phrase that means a case omitted. It refers to situations or issues that have not been specifically addressed or provided for in a statute. This can be either because the situation itself was not anticipated when the law was written, or it has been left out by oversight. The general rule is that if there are significant gaps in a law, then the court cannot fill these gaps with its own interpretations. For example, when cryptocurrencies started becoming popular in India, then there were no rules or laws that specifically governed how these cryptocurrencies could be bought, sold, or exchanged. Then there were some situations where there were some disputes, but these situations were not covered under the existing laws, because the existing laws did not anticipate the unique requirements of cryptocurrency related issues. Here, the judges should not try to plug the gaps through their own interpretations. It is up to the legislature to decide as to how they wish to address these issues around these new technologies and create appropriate laws. This rule has been reconfirmed by the courts in some landmark cases, that the judges should interpret the law as is and not attempt to fill significant gaps in the statutes in the guise of interpretation. Since the basic idea here is to interpret the law as is, the advantages will be certainty or predictability, and also in ensuring that the process of creating laws is left to the legislature. The disadvantages are that this makes the laws rigid and there is an over-reliance on the legislature, leading to relatively straightforward situations not being addressed, just because there is no specific law in place. Ubi lex non distinguit, nes nos distinguere debemos. This is a Latin maxim which translates to where the law does not distinguish, we should not distinguish. In other words, if a law is written in a very generic manner that may cover a wider range of subjects or situations, then the judge should not create distinctions while interpreting the law. For example, if a notice says that vehicles are not allowed inside the park, it is using a very generic term vehicle. And if no distinctions are created, this notice is simply prohibiting any and all vehicles from entering the park. This is also a good example to understand how the primary and secondary rules of interpretation are applied. First, the golden rule is applied to interpret the meaning of the term vehicles to include only motor vehicles. After which, this secondary rule is applied. Since this board is not saying that cars are not allowed, or buses are not allowed, or motorcycles are not allowed, the law by itself is not creating any distinctions. As per this rule of interpretation, the judge should enforce the law as is, and not interpret it to create distinctions between different types of motor vehicles. Since the law is being interpreted as is, there is consistency, there is simplicity, and possibly fairness, since all the subjects, that is, cars, bikes, buses, etc., are all being treated equally. However, the disadvantages are that there is no flexibility, and it can lead to situations of injustice, since this approach does not distinguish between personal use vehicles and commercial use vehicles and public transport vehicles. Two important principles of interpretation that we need to understand together are beneficial and strict construction of statutes. There is a simple way to understand and remember these. Social welfare laws, labor laws, consumer protection laws, and environmental statutes, which are all intended for the benefit, welfare, or protection of the people, should be interpreted beneficially. The idea behind beneficial interpretation is to ensure that none of the intended beneficiaries of the statutes are excluded, even if the benefits are extended to those who may be on the borderline of the scope. The focus is on the intent or the purpose of the law, which is to extend benefits. If there is any doubt with the law, then the benefit of the doubt should go to the people. Tax laws, criminal or penal statutes, which can impose a burden or a punishment on the people, should be interpreted strictly. The idea here is that the scope should be strictly limited to what is clearly stated within the law. The judges should not extend the scope of the law to include situations, transactions, or subjects that are not specifically stated. Here, the focus is on the literal text of the law. If there is a doubt, then the benefit of the doubt should go to the persons who are being taxed or the persons who are being accused. So, whether a statute is being constructed beneficially or strictly, the benefit of any doubts will always go to the people. Beneficial construction of statutes is typically used in interpretation of social welfare, labor, consumer protection, and environmental legislation. The main purpose of such legislations is the welfare of the people, to extend some benefits, or for the protection of people. Here, the statutes are interpreted in a way that the purpose of the legislations are fulfilled. The benefits or the protections are extended to all the intended subjects, even if such an interpretation is increasing the scope of the law. In other words, if there is a certain degree of doubt, then the benefit of the doubt should go to the people in question. If we look at this example case between the Employee State Insurance Corporation and Highland Coffee Works, there was a question about whether the employees of the said firm were covered by the ESI Act or not. Here, the court applied the principle of beneficial construction to interpret the ESI Act in such a way that the employees would be covered by it. This was done because the ESI Act is a social welfare legislation intended to protect the interests of the workers, and the benefit of any doubts should be in favor of the workers. Strict construction of statutes is also a very simple concept. In case of penal, criminal, or taxation-related statutes, they may impose a punishment, a hardship, or a burden on the people. So, such laws must be interpreted strictly, so that only those situations or transactions that are specifically mentioned in the law are covered by it. In some landmark cases, the courts have ruled that criminal or penal statutes must be interpreted or constructed strictly in favor of the accused. And if there is an ambiguity in a taxation statute, it should be interpreted in favor of the taxpayer. As I have previously mentioned, if there is a doubt in a penal, criminal or taxation related statute, then the benefit of the doubt should go to the persons being taxed or the persons being accused under those statutes. With that, we have come to the end of this part. If you have any questions or feedback, post a comment below. Thank you for your like, share and subscription. I will see you soon in the next video. Take care and Jai Hind.